freedom is never more than one generation away from extinction. We didn't pass it on to our children in the bloodstream. The only way they can inherit the freedom we have known is if we fight for it, protect it, defend it, and then hand it to them with the well-taught lessons of how they in their lifetime must do the same. And if you and I don't do this, then you and I may well spend our sunset years telling our children and our children's children what it once was like in America when men were free.
Welcome back, everyone, to Patriot Coalition Live. I'm Matthew Nugent.
And I'm Jason Morochek.
Thanks for joining us today. Our goal is to create a timeless resource to teach about the U.S. Constitution and the proper role of government, the importance of America's Judeo-Christian heritage, and how to defend against threats to our republic. Folks, we have an email address. We'd love to hear from you. freedom@patriotcoalitionlive.com. That's freedom@patriotcoalitionlive.com. We'd love to hear from you. Okay, and remember, folks, we have some fantastic sponsors. Remember that wherever we spend our time, attention, and dollars, we empower. You know the enemy out there, and one of the biggest enemies is Amazon. They have done so much to destroy our free speech and so many rights, particularly canceling companies. Of course, Amazon's not the only one out there. Google is too. So that said, we want to introduce one of our new sponsors, and that is Clear Mobile, C-L-E-A-R Mobile, Clear Mobile. Now, Clear Mobile is unlike other mobile providers. Now, it does provide a very competitive service in terms of your phone service, mobile phone service, but it's very different. They have their own phone operating system. Now, you've heard you need a VPN. You do need a VPN because based on your IP address, you can be tracked. Here's something else I just found out. Whenever you click on an app, there are 20 to 30 plus companies that are tracking you. They're actually tracking you. So even if you have a VPN that anonymizes your IP address, guess what, folks? Your apps still have GPSs. And if you go to the same house every night, to the same address where you live, guess what? Your name at that address is on a database, which is easy to cross-reference and say, oh, this anonymous VPN, which changes every day. They change depending on the provider. Guess what? You're no longer anonymous. And I have seen their Clear Mobile has their own cell phone. Okay. Now you can transfer your own phone to Clear Mobile phone service and just get a great deal. But if you also want their proprietary phone and proprietary phone operating system, you can not only anonymize your activity, but they won't be tracking you. Okay. Now, it is amazing what this phone can do. It for freedom-loving Americans who love their privacy and don't want to be tracked, people are going to get this. And we are so proud to be teamed with Clear Mobile. Now, to get this, what you do is go to our website, patriotcoalitionlive.com. That's patriotcoalitionlive.com. You can either click on the banner and register, or you can go to our sponsor page and you can see Clear Mobile there. So,
Matt, remember, the best part about Clear Mobile in my mind, it's not Android, it's not Google, therefore, and it's not Apple, right? Both companies who are canceling people and apps left and right. So they have their own operating system, and you can use Android apps on it. So to me, it's a win-win. No Android, no Apple.
Yes. So when you use Verizon, for example, or if you use, a Samsung phone, if it's using any of those operating systems that Apple requires or that Google requires, which is the Android operating system, you are helping them. Okay, but when you use a Clear Mobile phone, you are disempowering the people that want to destroy our freedoms, and you are helping us, folks. You're helping us legit. Okay, and you're helping a freedom-loving company and a free speech-minded company. Okay, so we do that for us. Thank you. Okay. All right, y'all ready?
Absolutely.
Let's do this. Okay, this week we're talking about the U.S. Constitution, Article 1, Section 3, the Senate. This is part 2 of 2. So as a review, Article 1, Section 1 was about the legislature, what's comprised of a bicameral Congress, two-part Congress, and that Congress gives all lawmaking authority to the Congress. Which
How much, Matt? How much?
I said all. That's spelled
Okay.
ALL.
So just to do some quick math, how much does that leave for any other organization in the government?
Zero.
Okay, thank you. I just want to
The
check.
opposite of all is zero.
Yeah.
No.
Okay. Just checking.
And why does Jason bring that up? Because there are thousands of laws that are fiat laws based on these little, kingdoms, fiefdoms that are through these czars. As a drug czar, I mean, it's
Regulatory agencies,
regulatory,
judicial decrees, whatever it happens to be. Yep.
fiat law. So yeah, and it's worthy of commenting. And so Article 1, Section 2 talks about the House, and we're now on Article 1, Section 3, which is on the Senate. We talked about the first part of the Senate last time. We talked about how this determines the number of senators, the senators, the state's proportional representation, the terms of senators, who elects the senators, the 17th Amendment, which changed how the senators get elected, and that it was a very contentious clause. Now, this week, we're finishing out Article 1, Section 3 on the Senate, so we'll go into it now. Here we go. This has to do dividing into classes and
This is clause 2.
Yeah, clause 2, vacancies. Okay, quote, immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be in 3 classes. Into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year, and if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof, meaning the governor, may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. So, Jason, you want to comment on classes?
Yeah. So a long clause, but the bottom line here, or one of the major parts, is in the vision of the framers to make sure. Remember, this body was intended to be long-serving, more wise, more even-keeled. They wanted to make sure that not all senators were elected at the same time, and potentially cause a vacuum in institutional knowledge, in the amount of knowledge they have about the proceedings in the Senate, the laws, how they operate. So they wanted to keep some of that knowledge on hand at any time. So the way that they solved this problem was they divided all the senators into 3 classes. And they just call them classes, 1, 2, and 3 is technically what they're called. And so what this does is it allows, any given election year, only 1/3 of the senators, either 33 or 34, are elected that year. That means at a minimum, 2/3 of them will still be there to help the new senators come on board and understand things and provide some of that consistency, if you will. So that's one of the big takeaways.
Okay. So thank you, Jason. The next part of that clause is, quote, the executive thereof may make temporary appointments until the next meeting of legislature. This means that the governor makes temporary appointments, but however, the 17th Amendment changed the process, okay? The 17th Amendment goes on to say this, quote, when vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as legislature may direct. Okay, so different states, what that says is the governor does the election under the auspices of what that state's legislature agrees to. Okay, which is a really good plan, because it says, hey, yeah, the executive of that state, the governor, he makes the decision, can make it quickly, but the legislature's got to have their hand in the game, skin in the game.
As you pointed out in the previous episode, they provide the guardrails, right? They say here's what you can do when there's a vacancy, Mr. Governor, and then he just executes on their law.
Yeah, I mean, some states, it varies. For example, some states, for example, Wyoming, the party of the absent senator, let's say a Republican senator, of the Republican Party, he dies in office. It happens. These senators, remember, senator from the word senex, meaning old man. Okay. Yeah. So I don't know how many senators have died in office so far, but there have been many. And so when that happens, say it's Republican, the Republican Party will come up with 3 candidates for the governor to select and appoint. And so when that happens in the state of Wyoming, for example, that's how the temporary senator will get in place in office. Okay, so and then now if their term, it says for the remainder of the term. So if the term is 1 day, they serve 1 day. If the term is 5 years and 6 months, they'll serve 5 years and 6 months until the new election. Okay.
Right. And as Matt's talking about there, now he's talking about one scenario where some states do it that way, right? And each state, again, the state legislatures get to choose.
Yeah. So it's the authority of each state to choose. Now, right now, there's HR 1. There are a lot of terrible things about it, and where the central government, some people say the federal government, it's actually the central government, is attempting to dictate how the states shall run the election. Totally unconstitutional.
Absolutely.
It says the states shall run their own elections, period. So
and we brought up before in previous episodes that there are several places in the Constitution that dictate that these state legislatures shall conduct their own elections. This is just one of them. I mean, Matt just read to you from this section where it says, provided that the legislature of any state may empower the executive thereof to make the temporary appointments. Again, the framers put these powers in the hands of the state legislature. So for a central government authority like the Senate or the Congress, let's just say, for them to intervene in a state's power, they're basically trying to say, oh, we'll decide how you elect your elected officials. Well, that's not the way it's supposed to be.
Yeah, and the reason why, there are many reasons why. Here are 2 reasons why specifically in the Constitution it said in multiple places in the U.S. Constitution that the state shall be in charge of their own elections. 1, because it makes it harder for corruption to occur.
Yep.
Okay, and so when a state has its own elections, okay, that could have been a federal law, but it is good common sense. It's good jurisprudence. I get that has to do with law, so maybe that's not the best word, but it's very wise. Now, the reason why it was codified in the Constitution because of BS with HR 1, because they are trying to usurp the authority of the states.
Right. Yep.
And we'll talk about later how the Bill of Rights, the first 10 amendments came about because it was so important. These laws, these unalienable rights, that we had to make sure to put it in there in black and white, or it was, I don't know, maybe it was exactly white. It was kind of tan,
yellowish,
kind of yellowish gold, but so that, listen, these are the laws, you cannot break them.
Look, the framers knew that men left to their own devices, that we were sinful in nature, and that power is always the rival of power, as I think Alexander Hamilton said. We're always going to be trying to grab power as a people, right? So they knew this. They knew that they had to put limits in place. They knew that they had to protect the states from the central government trying to dictate to them how and when they can run their elections.
You got it. So Jason, you want to?
Yeah, I was just going to say, a couple other takeaways.
Okay.
Remember, so this is intended to be a body, the Senate, that is whose purpose is to provide stability. So it would be totally imprudent to have them all face re-election in one election. So that's one of the reasons why they divide them into classes. The second is, to prevent high turnover, right? Kind of going along with that last point is, we want to make sure that the turnover rate, the long term 6 years, that we're not just turning over that institutional knowledge every 2 years like it is in the House. And then if they were to have to face elections more frequently, that provides for very distracted members in a body that are supposed to be even keeled, calm, cool, and collected, and be a little bit removed from the passions of the mob, so they can hear what the people have to say, hear what their states originally are intending them to do, and then say, let me think about this. I don't have to face elections, so I know if you're really, fired up about something, you'll cool down before my next election, and I can do the right thing as opposed to trying to just cater to the whims of the mob. So all of those things are kind of takeaways from this clause. So let's talk about clause 3 now. Clause 3 talks about the qualification of senators. And this one says, quote, no person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. So this one's pretty straightforward. We're just trying to make sure here that they are on the older side. Remember, we have a life expectancy these days, 60s and
That was
70s,
old.
right?
30 was old back then.
Yeah, 30 was not necessarily a young person, right? They were probably middle-aged at that point at least.
Yeah.
And so they wanted somebody, again, on this side, more mature than, remember on the House side, it's 25. And so they're more wise, they're more mature. But also, remember it says, and who shall not, and been 9 years a citizen of the United States. They wanted to make sure that there was some loyalty, right? You don't want to just elect somebody who has no loyalty, hasn't been here a while, doesn't have any, interests in the United States. So they were just ensuring that they have the wisdom and the loyalty to serve in that body.
Got it.
Okay, so that brings us to clause 4. This talks about who is going to be the president of the Senate. This is different than the president of the United States, obviously. So it says, quote, the vice president of the United States shall be president of the Senate, but shall have no vote unless they be equally divided, meaning the senators. If they're equally divided, then the president of the Senate, meaning the vice president, will be able to vote. So there was some discussion here. There was some concern in the Constitutional Convention as they were debating this, that having the vice president as the president of the Senate would ruin the separation of powers, right? You don't want the executive branch to have any influence on what the legislative branch does. They should be separate. But in their thought process, they said, well, but if a member of the Senate, sitting member of the Senate was going to be president, and he only voted in those votes that were ties, then he wouldn't really be a senator. He would kind of be a token member from his state, and that wouldn't be fair to the state. So it didn't make sense to have one of the senators be the president of the Senate. So the solution was, okay, so the vice president of the United States will be the president of the Senate. He doesn't have any vote in the Senate because he's not a member of that body unless a vote is tied, and then he can come in and cast the tie-breaking vote. That way, his influence from the executive branch is minimized.
There you go. So, in fact, what does, other than that one vote to break a tie, Jason, and just to bang the gavel every once in a while or showing up for the State of Union address, I mean, really, does the vice president have any other power in the Senate? I mean, breaks a tie.
Other than, so if it's not stated in the Constitution, which in this case, it's only talking about his tie-breaking vote casting. Other than that, because it's not listed here, then the Senate in their rules gets to decide what powers the president of the Senate, meaning the vice president, has. So I don't know those off the top of my head, but I'm guessing that they would minimize those. And that's why they essentially give it to the president pro tempore. So.
Okay, so thank you, Jason. Now, adding a little context to this, in 1787, 1787 is in Philadelphia, Pennsylvania, at the Constitutional Convention. The delegates agreed to the Constitution. They didn't ratify it yet because it had to go back to the states. Okay, and they basically took the next 2 years for those delegates to go back to their states and have ratifying conventions, because in accordance with Article 7, at least 9 states must have ratified the conventions. Now, there were some very interesting comments that came out of those ratifying conventions.
Yeah. Actually, one of the delegates to the Constitutional Convention, his name is William Davie. He was a delegate from North Carolina. So during this period of time between 1787 and 1789, he goes back to North Carolina in their convention, in their ratifying convention, and he describes Clause 4 about the president of the Senate like this. He says, quote, "It might happen in important cases that the voices would be equally divided Indecision might be dangerous and inconvenient to the public. It would then be necessary to have some person who should determine the question as impartially as possible. Had the vice president been taken from the representation of any of the states, the vote of that state would have been under local influence in the second. It is true he must be chosen from some state, but from the nature of his election and office, he represents no one state in particular. He's talking about the vice president, but all the states he represents. It is impossible that any officer could be chosen more impartially. He is, in consequence of his election, meaning he was elected nationally, so he is, in consequence of his election, the creature of no particular district or state, but the officer and representative of the Union. He must possess the confidence of the states in a very great degree, and consequently be the most proper person to decide in cases of this kind. These, I believe, are the principles upon which the convention formed this officer, meaning the president of the Senate being the vice president of the United States. So he gives an insight into the thinking of the framers of the day in writing out this clause to make sure that it was impartial and it was somebody who wasn't going to be it was going to be in very, very contentious cases where it was a tie vote, somebody who represented everybody.
Yeah. So yet more brilliance and genius of our founding fathers.
Yes, sir.
They thought through this so well, and it is he will vote when there's only a tiebreaker.
Right.
So all right. So go moving on to clause 5 on Senate leadership. Quote, the Senate shall choose their other officers and also a president pro tempore. It's people just also call it pro tem, and also a president pro tempore in the absence of the vice president or when he shall exercise the office of president of the United States. So basically the alternate for the vice president when he's sitting as the president of the Senate, because he sits at the dais, which means the highest seat in the House or in the Senate, the upper chamber. And most of the time the vice president is not there.
Right.
When there's a a State of the Union, he is there, and he is but most of the time it's a president pro tempore, also called a president pro tem. Okay, yeah. and tempore is spelled T-E-M-P-O-R-E. So it's an unusual word. So, but this clause is straightforward and works in conjunction with clause 4. Since the president pro tem can vote as a senator, it alleviates the problems, meaning this clause did not violate any principles of separation of powers, and it did not prevent the president pro tem from voting on bills. Okay.
Yep. That's exactly right. So let's talk about clause 6. So clause 6 begins the Senate portion of an impeachment proceeding. Talks about trying the impeachment. So it says, quote, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Okay, so the straightforward part there is, when an elected official, remember, so an impeachment happens to anybody who holds public office. It could happen to anybody who holds public office. So in order for that person to be convicted on the charges that he was impeached, they have to have 2/3 of the senators must cast their vote to convict him. So that's the easy part, right? So then we also have the piece about who gets to sit as the Chief Justice, right? So in this clause, it says, when the President of the United States is tried, the Chief Justice shall preside. So we'll get to that in a minute, all right? So during the convention, the discussion around this really revolved around who should be the trier of these impeachment, these articles of impeachment. So the initial suggestion from somebody in the convention was to the trial will happen in front of the Supreme Court of the United States. It kind of made sense, right? They were the judiciary of the land, and so maybe they should they should try those cases. But the problem was that, and we'll talk about a little bit more, is the impeachment articles are not criminal offenses. They are essentially political offenses. And so to have the judiciary who sit on that doesn't necessarily make sense, right? There's also a suggestion that was made that the president, after he's impeached, but before he's tried, he gets suspended. So he's not in office during that period. And somebody rightfully brought up that that doesn't make sense because it would give way too much power to the House of Representatives. Because it wouldn't be like, all they would have to do is just impeach him, and then he couldn't do his job.
Yes, all they need is a simple majority.
Yeah,
which they tried to do to Trump, twice. I mean, a couple more impeachments, he can get a free sub at Subway.
Oh my gosh! Can you imagine a second term?
I borrowed that from the Babylon Bee. If you guys ever heard the political satire website, the Babylon Bee, oh my God, it's so hilarious.
Yeah, can you imagine if he had a second term? Like how many more times they would have tried to impeach? Oh my goodness. Anyways, and then so one of the delegates from Maryland to the Constitutional Convention, his name was James McHenry. He made this comment. This is regarding the Senate and their trying of impeachments. He said, quote, "And the power of trying impeachments was lodged with this body," meaning the Senate, "as more likely to be governed by cool and candid investigation than by those heats that too often inflame and influence more populous bodies," right? Meaning like the House of Representatives or any other body with a whole lot of people. So his point here is like, look, we've already said that this body is supposed to be the more wise, the more calm, cool, collected. This is what you want a jury to be, right? And so, little did they know, well, maybe they probably did, how partisan the Senate would be at this point. So getting back to that brings kind of the whole point of, well, we just had two impeachments and two trials. Both trials, obviously, for President Trump were unsuccessful.
We're working on his Subway card, his free Subway.
Right, he's not quite there yet, but so he went through those. The second time, he had already been voted out of office, supposedly, under suspicious circumstances, at best. And so he was no longer president. And so people are like, well, why didn't the Chief Justice sit as the presiding judge for his second impeachment trial? And the reason is, again, getting back to the text. Now,
is this what the Chief Justice says, or this is what you?
No, this is the Chief Justice just has an opinion. This actually comes from the Constitution, which is the governing document. It says, when the President of the United States is tried, the Chief Justice shall preside. So now remember, at that time, the Donald Trump was no longer president. So according to the text, the Chief Justice doesn't have to preside. He could have, he chose not to. Okay, so that's the reason, in case you hadn't heard any of the shenanigans that went on with that, that's why he was not required to be the Chief Justice during that time. So that takes us to Clause 7. So this is the final clause of Article 1, Section 3. And this has to do with, okay, what happens if an elected official is judged and convicted of his impeachable offenses? And we're going to elaborate a little bit more on that here in a second. But let's read the text first. So Clause 7 says, quote, "Judgment in cases of impeachment shall not extend further than to removal from office," that's one thing, "and disqualification to hold and enjoy any office of honor, trust, or profit under the United States." That's the second thing that the Senate can when they convict, can make as a penalty, right? So to hold an office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Meaning, once they've been removed from office and prevented from running again, they can still be tried for that crime in a criminal court, civil court, whatever, separate from the political trial that the Senate holds. All right. So go ahead, Matt.
So in terms, a couple of points about the impeachment. And so there were two clauses, Clause 6 and Clause 7, that both have to do with impeachment. Yep. This is a hot topic right now. Okay. So two important points about the impeachment. Okay. Number one is the level of severity of the crimes. Okay. The level of severity of the crimes. Now, we're going to speak to both the letter of the law and the spirit of the law, also called the intent of the law. Okay.
Right.
So Article 2, Section 4 says, quote, the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors, period, unquote. Okay. So that's the level of severity. Okay.
So it
So
essentially tells you what it is that they can be tried and convicted for in an impeachable offense. Yep.
Right. Now, the letter of the law says that that there's an impeachment and then there's a trial. Now, it's called the impeachment process. People say because the House impeaches, the Senate tries and removes someone from office. Now, so the House. So by the letter of the
let me
law,
jump in there real quick. So again, we talked about this. The impeachment is kind of like the indictment. So a grand jury saying, "Oh, did his crimes really rise to that level?" And then that's the impeachment. And then the trial of that's where the Senate acts as the jury. So that this is the correlate, not the correlate,
and the judge and the judge.
Yeah, and of course there's a judge there as well.
They vote. Yeah.
So this kind of helps you see it in the terms of everyday courtroom drama.
Here you go. So the letter of the law states that all it takes is for an impeachment to kind of pass the House and be sent to the Senate is a simple majority. That's it. So it doesn't, I mean, so what? So that's all. That's the letter of the law. Now, the spirit of the law or the severity of the crime. So the context. Now, so Jason and I are going to give you our opinion on was Trump's second impeachment. We're just going to speak in context to that, okay? Not the first impeachment. That's another conversation, okay? But on the second impeachment, did it meet the letter of the law and did it meet the spirit of the law or the intent of the law? Okay, so did it meet the letter of the law in terms of getting the vote from the House? Yes. In terms of the severity of the crime, okay, the fact is on January 6th, the riots in Congress, Trump gave a speech that was a 45-minute walk away. Okay, and there were people on the other side of the long walk called the mall in Washington, D.C. And there's no way those people could have got there. And he said, let's walk down patriotically and peacefully. Now, was that a high crime of treason, bribery, or other high crimes or misdemeanor? No.
Matt and I say no.
Was it wise? No. What he just should have said was goodbye, So now,
but frankly, it wasn't up to us, right? Those of us who witnessed it and in reflection that are common sense, we say, no, that there's no way that rises to that level. But again, this was a political.
That's right.
Impeachment is a political process. So you have partisan operators in the House who get to make that decision. And to Matt's point, a simple majority.
Now here's another reason that we have to look at the letter of the law and the spirit of the law. Now let's take something that's very real right now. Let's take a look at the traitor in chief. I did say that, the traitor in chief, Joe Biden. Now there is a lot of evidence. I mean, it actually shows, for those of you who don't know, need a review. Okay, Joe Biden's son, Hunter, left a laptop that had thousands of pictures and thousands of emails that showed that he has been involved with Ukraine, Russia, and the Chinese Communist Party in taking money from these entities to garner influence of the then vice president and now President Joe Biden. Now, it was
essentially soliciting bribes.
Yes, that's bribery.
Yep.
It's bribery. Do I sound passionate about this? Yeah,
as you should.
I am. Yeah. So that said, okay. So if now, so does that meet the spirit of the law of treason? Excuse me, of impeachment? Yes. Okay. Now, the letter of the law states that when someone gets or for an impeachment process to get a go to be sent to the Senate, it needs certain technical aspects of the process to occur. It needs a simple majority, at least 50% of the House of Representatives, and then it gets sent to the Senate. Now, here's the question. Okay, let's. Um, I doubt that Biden will be impeached because
I'm not holding my breath.
yeah, I'm not holding because why? Because as Jason mentioned, it is a political process, and right now the party in power in the House of Representatives are Democrats, and so they're not going to impeach him. Okay, so that said, if it were to happen, though, let's say in 2 years, if Joe Biden is still in office, Jason said, "Not my breath,"
Again, not holding my breath.
because there's already talk about the 25th
He's old,
Constitutional
feeble, and
Amendment.
demented. I think that's what you're trying to say.
Yes, because it's going to be enacted, and Biden is most likely going to be removed from office or step out. So anyway, so let's say that he does get impeached. He's around 2 years, and Republicans are in power, which there's a very good chance they will be. It's just going to happen, okay? And let's say we're going to impeach him, and there is a ton of evidence for it, okay? And this does meet the spirit and the letter. The spirit meaning it is high crimes and misdemeanors, treason, bribery, or other high crimes and misdemeanors, and he gets the 50% simple majority in the House of Representatives. Then it goes to the Senate. Now, equate that to today. Now, Trump is no longer in office. Now, the letter of the law is written such that if someone, for example, Biden, he gets impeached, he resigns. Did he commit treason, bribery, or other high crimes and misdemeanors? Yes. Okay, based on what evidence we've seen and what has been censored and blocked from the media, yes, he has. He's been doing it for years, probably decades, actually. So that said, what if he tries to escape? And so I'm just getting away from it. He can still run for office in the future.
So Matt, what you're saying is if he decides to resign before his trial in the Senate,
yes,
he would not face the consequences of the letter of the law, meaning he cannot run for office, of profit or influence here in the United States.
That's
basically
right.
Run for office, yeah.
So now the letter of the law states that process in the context of Biden would be correct. Okay. Now, who decides whether something meets the level of treason, bribery, or other high crimes and misdemeanor? The political party in control, which right now it's the Democrats.
Right.
Now, in a couple of years, it's going to be the Republicans. Okay. So based on the letter of the law, if that were to happen and Biden were to be impeached, then it would go to the Senate. But hey, let's say he resigns. And can he or should he still be tried in the Senate to keep him or to hold him accountable for those crimes? The answer is yes. Okay,
right.
Now let's take that to Trump. Now, is it by the letter of the law legal by the Constitution for him to be impeached? Well, he was in office when he was impeached, but he was out of office. Now, by the letter of the law, yes.
Out of office during his trial.
During his trial in the Senate.
Yep.
So by the letter of the law, is it constitutional? Yes. By the spirit of the law, is it right? The answer is no. It is despicable.
Yeah,
it is despicable.
And this gets to, right, if we're going to be a principled government, if we're going to have, these principles espoused or, codified in the Constitution, what's good for the goose is good for the gander. It can't just be for one party or another or whatever. So if it's legal and right for one party, it has to be legal and right for the other. But to Matt's excellent point, the spirit of the law, it has to still rise to the level of actually having committed those crimes, right? And that, in our opinion, is where they went horribly wrong, right? And so what's the remedy for that? What's the takeaway? If enough people believe that Chuck Schumer, Chuck Toomer, in the Senate was wrong in proceeding with that and holding that trial, if enough people believe that, then they should turn him out of office, right?
That's right.
And whether that will happen or not, we don't know, but that is the constitutional remedy to that problem of somebody violating the spirit or the intent of that law.
So the scary part for me is this: you mean enough people can get elected, like Nancy Scary Pelosi? Oh my God, that woman is the devil reincarnate. I mean, it's just evil woman. Did I say that? Yeah, I did. And they do not care about you; they care about power.
That's right.
It just goes to show. Now I'm a sinner saved by grace. Jason is too.
Guilty.
Okay, yeah. You know, and hey, when we each meet our makers, I know Jason has said this. I tell you, I want to hear, "Well done, thy good and faithful servant." Um, the fact that a majority in office can do harm just because they're elected, and it's often because we just don't take enough action. We just don't take enough
Yeah,
action.
we're complacent.
And you know, freedom is worth fighting for, and you got to fight for your whole life. You know, our liberty, what we got today, was purchased with blood, sweat, and tears, blood and treasure, lives. You know, we've been given a great gift, and I don't want to forsake that.
That's right.
And so, Jason, you got a great quote from somebody.
I
Tell us
do,
about
but
that.
I was thinking that I was thinking about John Adams first. He had a great quote to Matt's point, about the letter of the law, right? He said, "Our Constitution is made only for a moral and religious people. It is wholly inadequate to the government of any other," right? You can write laws that are very straightforward, and you can have people who twist and usurp and find holes and gaps in those laws, right? The Constitution wasn't supposed to be super specific and apply to every single thing under the sun. On the other hand, they said some very specific things, but that leaves a lot of room for unscrupulous people to do
That's right.
wrong under the cover of authority. And so John Adams quote, again, "Our Constitution was made only for a moral and religious people. It's wholly inadequate to the government of any other." Well, if you're not moral, you can say, "Oh yeah, that's what the law says," and do just about anything you want to do. And that's his point, right? And it's interesting because I have Jefferson is one of my all-time favorite. Between him and Madison, those two, man, I'm always in awe anytime I read any of their writings. But Jefferson had another great quote. He said, "My principle is to do what is right and leave the consequences to him, capital H, who has the disposal of them." Meaning, look, my responsibility is not to make sure everybody does everything they're supposed to do. I have to do what I know is right. And God's going to take care of the rest, right? I have to do my
That's right.
best, right? And so, when we're faced with the decisions about, man, is this right or wrong, or how are we going to prevent this or that? Just do what you know is right, and leave the rest to Him, right? We're planting
Yeah.
seeds. That's all we're doing as we go along here. So,
Yeah, it says, what does God say? And as the leftist and socialist, and there's a great book you guys ought to read by Skousen, Skousen, that it's called The Naked Communist. And what we are experiencing today in America is people are kicking God out. And Jason, you said it was Jefferson said that our Constitution is wholly unfit for an ungodly people.
yeah.
And when you
Adams.
take God out of the equation, what's going to happen is people are going to be like, yeah, whatever. Yeah, murder babies, okay. Yeah, just and on and on and on and on. So
Yeah.
understand this, faith matters, religion matters, and what you do matters. Okay.
Right.
So
It's kind
anyway,
of like saying, an analogy is like if I tell, Matt, say, "Hey, Matt, what do you have out there in Florida? I-95, is that right? Interstate 95."
I-95, that's right.
Yeah. So if I say, "Hey, Matt, hey, take, go out and take I-95, and you'll get to the right place." Well, if Matt goes and goes south, he may be going to the wrong place. If he goes north, he's going to the right place. A law is something similar, right? You've got that law is the interstate, but it's your morality that lets you know which way you're going to go on it, right? Are you going to use it for the right purposes, or are you going to use it for nefarious purposes?
That's right. So if you care, get involved. And all right, so Jason, you want to wrap us up?
Yeah. So again, so kind of just summarizing Article 1, Section 3. Last week we talked about Clause 1. This week we finished out with the rest of the 6 clauses, which dealt with the classes and the vacancies. Why they divide them into classes. What happens if somebody dies, resigns, or is impeached. And then what the qualifications are. Who gets to be a senator? Is it just anybody? It's somebody who's newly arrived to the country if they're 12 years old? No, it's got to be the right type of person. It also talks about how they elect their leadership within the Senate to figure out so that body can be organized and get the business of the people done, and the states, I should say, because that's what they're originally intended to represent. And then the last two are about the impeachment trials. One is, what their power is in the impeachment and who gets to preside over and so forth. And the last part is, the judgment of the impeached officials. What is the extent, what punishments can they issue to those who they find guilty of the impeachable offenses? So hopefully you've been able to follow along for the last two episodes, and you have a better understanding of what the Constitution says about the Senate. But of course, if you have any questions, you can always email us, freedom@patriotcoalitionlive.com. That's freedom@patriotcoalitionlive.com.
Awesome. Great job, Jason. Thanks for following us today. Remember, guys, check out our sponsors, our new sponsor, Clear Mobile. You can check that out at patriotcoalitionlive.com, either on the link on the main page, or you can go to our sponsor section. You're helping a freedom-loving company, and you're helping us out. With that, folks, thanks a lot. We'll see you here next time.
Keep your powder dry, gang.
Keep your powder dry and get ready. All right, bye now.